Good day and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion among experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we're getting high on innovation with a deep dive into cannabis patents. As more and more states relax restrictions on both medical and recreational uses of marijuana and hemp, the U.S. cannabis industry is projected to reach $50 billion in sales this year and over $74.6 billion by 2032. This rapid growth is happening despite immense challenges brought on by a complex and conflicting web of legal disparities between federal and state laws. These legal challenges include limited access to financial institutions and the inability to transport products across state lines. But what about patents? THC, the primary psychoactive compound in cannabis, was deemed a Schedule I drug under the Controlled Substances Act of 1970. This is the most restrictive category for drugs in the eyes of the federal government. And unlike most other property rights, patents fall squarely within federal jurisdiction. So what does this mean for inventors in the space hoping to protect their cannabis-related innovations? For the answer, we turn to the expert in the space. There have only been 5 or so cannabis patent infringement cases ever filed in the United States, and our guest host today has worked on 2 of them. James Gorley is a partner at Karstens, Allen & Gorley, LLP, and a registered patent attorney with the United States Patent and Trademark Office. James served on the Dallas Bar Association's Intellectual Property Section Board before moving to Denver. He is a member of the State Bar of Texas and Colorado and is admitted to practice in the U.S. District Courts for the Northern, Southern, Eastern, and Western Districts of Texas, the District of Colorado, in the Fifth Circuit Court of Appeals, and the United States Supreme Court. James has been a pioneer in the budding space of cannabis IP law and brings incredible depth of expertise based on firsthand experience to our conversation. In today's episode, James helps us cut through the haze of the IP legal landscape of cannabis in the U.S., at a time when some states have legalized it to varying degrees while others haven't, and at the same time, while cannabis remains federally illegal as a highly restricted Schedule I drug. Yet, despite the contradiction, the U.S. Patent and Trademark Office happily issues federally granted patents on cannabis-related inventions. In fact, and here's a kicker, even the Department of Health and Human Services holds a patent on using cannabinoids as antioxidants and neuroprotectants. This is the same federal agency whose findings around quote-unquote no accepted medical benefit are partially responsible for the Schedule I classification. But if that weren't enough to leave you feeling dazed and confused, it gets more complicated when you consider enforcing your cannabis patent rights. Federal courts have refused to get involved in resolving disputes that would essentially condone illegal activity. The illegality doctrine implies that if you're involved in financial transactions with somebody who's violating the Controlled Substances Act, and you're trying to facilitate that, you're essentially guilty of money laundering. To little surprise, courts want no involvement in such cases. Depending on how you've crafted your claims, you may have a very difficult time asserting your federally obtained rights in a federal courtroom. To help make sense of all of this, and so your IP rights don't just go up in smoke, James and the panel discuss cannabis at the molecular level, specifically THC and CBD, and how the subtle differences underscore the complexity of cannabis legality, the present legal framework around cannabis and the challenges that come via a patchwork of conflicting state and federal laws, cannabis IP issues surrounding obtaining and asserting both patents and trademarks, including insights from cases James has personally litigated, and some patent prosecution strategies to help ensure your rights are enforceable in a federal court. James leads this blunt conversation with our always exceptional group of IP experts, including Dr. Ashley Sloat, President and Director of Patent Strategy here at Aurora, Dr. David Jackerl, President of Jackerl Consulting, Kristen Hansen, Patent Strategy Specialist at Aurora, and Marie Smith, Patent Agent at Brake Hughes Bellerman, LLP. Now, before jumping in with the panel, we'd like to take you to the next installment of the Mossoff Minute, a monthly segment that builds on our Patent Wars episode and features short conversations with Professor Adam Mossoff, providing updates and quick takes on movements in patent reform, significant court rulings, innovation policy happenings, and occasional Star Wars references. In this month's Minute, Adam discusses 6 new anti-patent bills that the Senate Judiciary Committee recently advanced despite being backed by bogus data.
Some big news in the patent law world, unfortunately bad news, is that the Senate Judiciary Committee advanced recently 6 bills addressing drug patents and drug pricing. These bills are based on long-standing and long-recognized anti-patent rhetoric. We often hear these terms called evergreening and patent thickets. that accuse patent owners and innovators of abusing the patent system. This is not based on any actual real data. In fact, the US Patent and Trademark Office just recently confirmed that the data that has been thrown around in these debates and that underlie these terms is bogus and unconfirmable. And it's really unfortunate that Democrats in the Senate and some Republicans who have joined them are looking for an easy scapegoat for what is the complex problem of drug pricing in the United States, ignoring all of the regulations and statutes and other institutions that contribute to these problems, like PBMs and even the Obamacare regime. Stay tuned for more on this, but hopefully the full Senate will not take action on these bills.
Thanks, Adam. We're also publishing clips from the Mossoff Minute and short-form videos on Instagram Reels, YouTube Shorts, and TikTok. You can check out these shorts and follow us at Aurora Patents on all 3 platforms. And now, without further ado, I'll pass it over to James.
All right. So first of all, I want to talk about what is cannabis. I think when someone says cannabis, most people think about Snoop Dogg smoking a marijuana cigarette, and that's certainly part of it. But when you're looking at legal issues related to cannabis, it's quite a bit more complicated than that. And so before we really get to the IP issues with cannabis, I've got to give you background on the legal framework that applies to cannabis generally, because it dictates a lot of what happens down the line. So when we're thinking about cannabis and what most people are interested in, it is 2 molecules that are found in the cannabis plant. One of them is THC, tetrahydrocannabinol. The other one is CBD, just cannabidiol. And these 2 molecules are actually very similar to one another. They have the same molecular formula. They have almost the exact same molecular weight. And the difference between different cannabis plants is some are much, much higher in THC than CBD, and others are much, much higher in CBD than they are in THC. And I've got a slide up that shows the structure of both molecules, and you can see that they're very close to one another. And really the only difference is there's a ring structure in the middle, and in THC that ring is closed, and in CBD that ring is open. So other than that, they look very, very similar to one another. And that seemingly minor structural difference causes a very major difference in how the human body reacts to these chemicals. And THC is the one that is intoxicating. So, a lot of people, when they ingest THC, they feel feelings of like euphoria, maybe a high enough dose, maybe a little bit of psychedelic things. And CBD just really has none of these effects. There's some literature that talks about it being sort of like an anti-inflammatory, a little bit of literature on it maybe being a sleep aid, but it really does not CBD does not make you feel anything remotely close to the way THC makes you feel. So, and just to give you an idea about about CBD's sort of biological effects, there was a study published in 2019 where my reading of it is they almost like tried to kill mice by administering super high doses of CBD, and were not able to do that. So they gave mice CBD at levels that were over 2,400 milligrams per kilogram of body weight. And if you translate that over into like an average human body, it's about like a baseball size amount of pure CBD that they gave to these mice. And really the only thing they observed is that they were kind of like lethargic and had reduced activity and reduced appetite. So, CBD just doesn't do like a really a whole lot to the mammalian brain or body. But THC certainly does. So that's the 2 main differences that we're thinking of when we're thinking about different cannabis products.
So James,
And then, yeah.
let let me ask you a quick question. When we get to the IP part,
Yeah.
are we talking all plant patents, or are we talking maybe some pharmaceutical combination plant?
Yeah, so there are composition claims, patents, about different, topical compositions, edible compositions, certainly, pharmaceutical claims. There are also a lot of processing patents. There's different ways to extract these molecules out of the cannabis, and there are patents around that. And then there are ways to sort of take these chemicals and do certain things to them to like increase or decrease their activity. So it's really almost anything you can think of around what to do with these molecules. People have either patented or tried to patent them.
Okay, great, thank you.
Yeah, we'll definitely get into that. You'll see some examples. And then, so again, before we get to the IP, we got to talk about the legality of these products. So, is it legal? The answer is a classic, lawyer answer. It depends, sort of. I have a map up on the screen that shows that breaks down the legality under state law. It breaks it down 6 different ways. Fully illegal. It's still fully illegal in some states. Several states allow CBD only, no THC. It's sort of decriminalized in some states, which can mean, you're not going to jail if you're caught with it, but you may get sort of like a traffic ticket. So those are the states where it's decriminalized.
So it's still illegal in those states, but your penalties are much less severe.
Right. Yeah. So you're not going to jail, basically, is the thing. And some states it is legal medically, so you can get like a medical card and go to a medical dispensary and get the products. Some of those medical states have also decriminalized it, and that's broken down by color on this map as well. And then there are a bunch of states that have just totally legalized it. Like my home state of Colorado, it's totally legal here, California, Oregon, Washington, a bunch of states on the East Coast. But even, as colorful as this map is, and as much as it breaks it down by different categories, that doesn't even give you a full picture of the legality, because in Colorado, for example, even though it's legal under state law, the state law allows local jurisdictions to place even more restrictions on it than the state regulators do. So, for example, I live in Jefferson County, which is west of Denver, and the voters in Jefferson County decided that they don't want it grown, manufactured, produced, or sold in their county. And they passed a law in Jefferson County where you can't make it or sell it in Jefferson County. So it's even, you can even break it down even more than what's shown here. And it's really, really difficult for companies in the space to comply with all of the laws and regulations in all the different states. So, the other thing I want to say, just kind of the history of it. California was the first state to legalize medicinal marijuana back in 1996, and Colorado came in 2000 with the same thing. But Colorado was the first state to fully legalize it in 2012, and that was before California. So it's just some history there. And then next, we're looking at the legality of marijuana or cannabis on the federal level. And on the federal level, it essentially, there's a distinction made between hemp and high THC marijuana. So the first thing I'm going to note is that the Controlled Substances Act classifies cannabis as Schedule 1. It's a Schedule 1 drug, which is the most restrictive category for drugs under the Controlled Substances Act. Drugs are classified in Schedule 1 because the United States government has determined that drugs in this category have no accepted medical benefit, and there is a high potential for abuse. And the government makes this finding by using supposed, experts at the Department of Health and Human Services who, investigate it and determine whether there is an accepted medical benefit and a high potential for abuse. And if they make that finding, then they categorize it under Schedule 1. There are other, so cannabis is in the same schedule as things like heroin, LSD, and psilocybin, which is the active ingredient in magic mushrooms. And a little bit more about the history. Cannabis has actually been effectively illegal since 1937. Congress passed something called, I think it was the Marijuana Tax Stamp Act, which ostensibly allowed people, companies to use or sell marijuana if they had a tax stamp from the government. But in practice, they never issued any of those tax stamps. So it was effectively illegal since 1937. In 1970, Congress came through with the Controlled Substances Act and put even tighter restrictions on cannabis and many other drugs. Interestingly, a couple of drugs that are not in Schedule 1, they're in Schedule 2, are things like cocaine and opioids, which are, responsible for a lot of deaths in this country. So it's kind of an interesting distinction that doesn't usually receive a whole lot of explanation. But so we've got 1970 up until 2018, cannabis was totally illegal under the Controlled Substances Act. Doesn't matter if it's THC, CBD, anything else, any classified under Schedule 1, totally illegal. You're going to jail for a long time if you make or sell it. In 2018, Congress came through with a farm bill that exempted something called hemp from the definition of cannabis under the Controlled Substances Act. And that farm bill defined hemp as any cannabis product with less than 0.3% THC in it. So starting in 2018, the DEA could no longer go after anyone who was making or selling hemp products. And as long as those hemp products had less than 0.3% THC, they were good. They were legal under federal law. And I think the intent there was to open up cannabis plants for other types of products like, clothing and paper, because the cannabis plant matter itself is actually useful for those kinds of things. So I think they were trying to make those types of agricultural products available from the American market. The actual effect it had is the market was flooded with things like, CBD tinctures and CBD lotions. And even lately, people are selling hemp-derived THC beverages and gummies and things like that, where they're claiming that, the product, the plant has less than 0.3% THC, but we're getting enough out of it to actually give the psychoactive effect in a final product, and they're claiming that it's hemp derived. So I don't think Congress really intended for that to happen, but that is what has in fact happened. You can get THC products all over the place in almost every state, and the purveyors of these products are claiming that they're legal under this 2018 Farm Bill. That hasn't been tested a whole lot, and it'll be interesting to see how that develops as the market grows for these hemp-derived THC products. But then there's another big however that I have to give, which is that even though CBD products are legal under the 2018 Farm Bill, they are still illegal under the Food, Drug, and Cosmetic Act, which is regulated by the FDA. So, there's a lot of, like I said, a lot of these products out there on the market, like CBD cream, CBD tincture, CBD gummies. And yes, they have less than 0.3% THC, but CBD does not fall under the category of generally recognized as safe. And the FDA has taken the position that you cannot include CBD as an ingredient in any topical, ingestible, inhalable product without FDA approval. And FDA has not approved it for anybody. So every one of those products is illegal under the FDCA. And the FDA, in theory, could go shut down every single one of these companies because they don't have FDA approval. But really what we're seeing in practice is that they've only really been enforcing this against CBD companies that are making medical claims. So they're claiming that CBD can, cure cancer or, whatever. And if the FDA is alerted to a CBD company making a medical claim, they will send them a letter to shut down and stop selling the product. And then before we get into the IP issues, I just want to say one more thing about these hemp-derived products on the market, and it's again, it has nothing to do with IP or really any legal issue, but I know a lot about this industry, and if you're ever thinking about buying a hemp product, a product that says it's hemp-derived THC, I know that a lot of these products contain THC that has been converted from CBD. So if we go back to the molecular structure, again, I pointed out that the only real difference is that this ring in the middle of the structure is closed on THC and it's open on CBD. So what a lot of people on the market are doing, and it's totally unregulated, is they're getting high CBD hemp plants and they are converting the CBD into THC. And the way you do this is you have to use an exotic metal catalyst and several very harmful solvents to accomplish this thing. And then they're separating the THC. They say they're separating the THC that you get as the end product. They're separating it from the catalyst and they're separating it from the harmful solvents. But you just really need to do your research and make sure that whoever's selling these things are giving you what you're asking for, which is something that is free of harmful metals and free of harmful solvents. Okay. That's just kind of like my own PSA that I have to get out there because I know
That's
I probably know.
crazy. I had no idea. So that's crazy. Like I had no idea that that's what they were doing. I mean, like for those, is that more, do you think that that's more for places that's not legalized? Do you think that's happening more in those places, or is it kind of across the board, whether the state has legalized it or not, that practice of converting CBD to THC is happening?
It is, I would say if you are buying a hemp-derived THC product that is totally unregulated, that they're claiming, if their argument for why it is legal is based on the 2018 Farm Bill, it's highly likely that it's a converted product. Now, if you're in a state like Colorado, they changed the rules a couple of years ago to completely prohibit any THC products being on the market that are made from converting CBD into THC. Like it's outlawed in Colorado.
Right.
So it's really a state by state basis. And I'm just saying again, like do your research, call the company, like find out what documentation they have. I mean, it takes some legwork, but it's totally worth it because again, like my background is chemical engineering. So I know quite a bit about manufacturing different chemicals and I understand all the processes involved. And there's actually a patent on this conversion process, one way of doing it. And it's just like a very exotic metal catalyst that I'm highly skeptical that whatever separation process they're using is going to be like totally getting rid of it. So, and there's one, I've even seen videos of this happening. Like at one point during the process that the whole chemical reaction makes it turn purple.
Oh.
And then, I mean, it's just not something that I would want to be putting in my body. But anyway, so
That's crazy.
Yeah. So now that we've got a good understanding of the legal framework around cannabis, let's look at the IP issues. So I know this is a patent, related podcast, but I did want to talk about the trademark issues because that's really interesting too, around cannabis. So what are the issues that come up with cannabis-related trademarks? So as I'm sure we all know, if you've got a product and you've got a brand on that product, one option for protecting it is to register the trademark with the USPTO. And we all know the way you do that is you fill out an application and you file it with the U.S. Patent and Trademark Office. And in that application, you have to, pick an international class. You have to describe the goods and services that you're selling under that brand, and then you submit it, and it gets examined by a trademark examiner. Well, the U.S. Patent and Trademark Office will not register any trademark if they believe that you are not using that trademark in accordance with U.S. federal law. And this doctrine that they use is called the lawful use doctrine. So it's not just cannabis. They've rejected trademark applications under laws relating to like pesticides, gambling, just like there are, 10 or 12 different examples of federal laws that have been used to reject trademark applications because the USPTO has taken the position that you're selling illegal goods. We're not going to be condoning that by giving you a registered trademark on it. Because I guess they think that it's giving it sort of like some sort of legal imprimatur from the federal government, and they're just not going to do it. Just a side note, I think that doctrine is on highly shaky ground, but nevertheless, you're not gonna convince the trademark office otherwise. So they're not going to register it if you submit a trademark application for any sort of high THC product. They're going to reject it. They're going to look at the application. They're going to send you a rejection, and there's pretty much no way you're going to be able to get around it. So, and this is because, THC is illegal under the Controlled Substances Act. So they're just not going to do it. So I guess that means that we can register CBD products, right? Because they are legal under the Farm Bill. But that's wrong too. The USPTO takes the same position as the FDA, that most of these CBD products are illegal under the FDCA, and the FDA has not approved them, so they're illegal too. So if you submit a trademark application on like a CBD beverage or a CBD cream, they're not going to register that either. Really, the only thing that can consistently get registered is a trademark on hemp flower. So you have to say in the goods and services description that it's hemp flower with a concentration of THC less than 0.3%. And if you do that, the USPTO will register your trademark. Of course, you actually have to be selling the hemp flower. It's not a super popular product. Everybody wants the high THC one, right? So there's not a lot of motivation for a manufacturer to be producing and selling the hemp flower by itself, because not a lot of people want that product. So it's not a great option for a lot of people in the cannabis space. So what are we supposed to do? One option to get something on the register is to trademark what we call ancillary goods. So things like clothing, lighters, rolling papers. There's even a whole category of cannabis companies registering their trademark for, quote, providing information about cannabis, which is not illegal, and other things like that. So you can get your trademark on the register. It's just not going to be for the product, the main product that you're selling, like your primary profit center. It's not going to be the product that's covered by your registration. But of course, the caveat here is you actually have to be selling these goods. We all know that you can't register a trademark until you're actually using it on the goods. So you can't just say, oh, I'm registering this for clothing or lighters. You actually have to be selling clothing or lighters. So that's another, it's just another cost of doing business. You got to actually have these products and be selling them before you can get the trademark. Another option is state trademark registration. So if you're selling cannabis goods in Colorado, you can register your trademark under Colorado state law. Get a state registration in Colorado. That way, if somebody is infringing your trademark in Colorado, at least you have something. And these state trademark applications and registrations are all kind of interesting too, because each state law is different. Sometimes these applications are examined in a way that's similar to the way the USPTO examines them, and sometimes they're not. Sometimes they just kind of go on the register, and when it comes time to enforce it, you actually have to prove that the mark is distinctive, and you're the senior user, and all the things. So it's really interesting. Another sort of patchwork of state laws can apply to cannabis IP. But again, it's not the greatest thing to have a state registration, because it only covers one state, but at least it's something.
James, on the federal side, I know you said the legal framework was maybe on shaky ground in your opinion, but have you heard any kind of an explanation for why on the patent, it's the PTO, same organization, but on the patent side, totally okay to file patents on illegal things, but on the trademark side, it's not okay? Have you heard any explanation for that?
I guess the difference could be that you can get a patent without actually practicing it, right? So,
sure. Got it. Yes.
Yeah. So I think that's the big difference, is they can say, hey, look, we're not condoning any sort of activity here. And if you look at the patent rights, what does the patent give you the right to do? Stop people from doing something. So basically the federal government's saying, hey, you can go out there and stop people from doing this. So it's consistent with the CSA from from a legal perspective. If all you're doing is going for an injunction, we'll talk about that here in a second.
That's pretty interesting. I at the risk of a little bit of a rabbit hole, maybe, but from a patent, it's an interesting patent question. My background is material science, and I do some chemistry related things as well. And we've talked a couple of times about sort of the unpredictable art side of things. So if you have a chemical or a biological invention, there's a higher bar for disclosure, and sometimes in the extreme, they want you to have actually reduced it to practice in order to have it be really enabled. Have you run into any? I mean, that seems like that's usually not something that a patent examiner, I guess, would say. It's something that comes up in litigation or on appeal, but I don't know. Do you have any thoughts on that, or?
Yeah, no, I haven't really seen that issue come up during prosecution. And a lot of the stuff is fairly straightforward. Quite honestly, I mean, my personal view on a lot of these cannabis patents is it's a lot of it is people just repurposing, processes that were already used to sort of like, I don't know, extract lavender oil from lavender plants, or, other chemicals from other sort of plant material. And I don't know that there's a lot of like new ground being tread here. Now, the one that I talked about earlier about converting CBD over to THC using a specific catalyst. Now that's kind of interesting. And, that one, I would say maybe there's some sort of enablement issue, and you'd have to actually probably do that and prove it before, before you get a patent. But stuff like chemical extraction, using solvents or pressure or ice water, whatever you want to do. I think a lot of that stuff is just ground that's been pretty well tread over the last 100 years. But
interesting. Yeah, thanks.
So let's see. So that's about all I have to say on trademarks. Like I just talked about, on the patent side, the USPTO will issue patents that cover federally illegal cannabis. This is a really funny example of one issued patent. So this was issued in 2003. It was well before anything cannabis related was legal under the Farm Bill. And it looks like a normal patent. It's got the patent number, it's got the inventors, it's got the title, cannabinoids as antioxidants and neuroprotectants. But the funny thing is, you look down here at the assignee, it's the United States of America, as represented by the Department of Health and Human Services. So on the one hand, you got HHS that has taken the position that there is no accepted medical benefit for cannabis as an excuse to keep it under Schedule 1. And on the other hand, they own this patent about using cannabinoids as antioxidants and neuroprotectants. Now, this is one that I've never seen explained adequately anyway. I mean,
it's like a double dip to me. I don't know, or a two-faced approach a little bit. I've always thought that when I bring this up all the time too.
yeah. So it's really funny that HHS has a patent at the same time that they claim that it has no medical benefit. So as I think was mentioned before, I have quite a bit of experience in different aspects of the cannabis industry. I've represented companies who are in a dispute with the Colorado regulators, actually, that have nothing to do with IP. So I know a lot about the industry, but I have been on the defense side of 2 patent cases involving cannabis-related patents. And the first one was back in 2018. It was filed in the District of Colorado, and it was United Cannabis versus Pure Hemp Collective. And I've got the U.S. patent number up here. It's 9730911. And one of the claims that was asserted against my client, I have, instead of typing it into my PowerPoint slide, I actually took a screenshot, a clip from the PDF of the patent, because I know there are patent practitioners on here who will appreciate this. This is a 2-line claim. This is the entire claim. It's 2 lines of the patent. And it is by far the broadest claim that I've ever seen in 20 years of practice. And I'll just read it. It's a liquid cannabinoid formulation wherein at least 95% of the total cannabinoids is CBD, cannabidiol. And this patent has another claim that it's the exact same, except it says at least 95% is THC. It's got another one that says at least 95% is CBN, which is another cannabinoid. And then there are a bunch of other, dependent claims that didn't really add anything, that also included things like terpenes, which are naturally present in the plant. It was shocking to me when I saw this patent that it actually got through the U.S. Patent and Trademark Office, because the priority date was something like 2014. There is just an absolute ton of prior art on this patent.
Are we sure there's not like a co-ethnicity of the United States government and they just wanted to get in on this? Because this is ridiculously broad.
Yeah, I know.
They wanted to start making themselves.
Well, this was owned by it was owned by a company called United Cannabis Corporation. So it was a private party, but
Sure.
I looked up back when I was working on this case, I looked up this examiner statistics, and I think they had an allowance rate of like 85% or something like that. Like, it was one of the easier examiners. If you're prosecuting patents, this is definitely like an examiner that you would want to draw. So anyway, this is one of the cases that I worked on, and we ended up winning this case. Like, finally, at the end of it, the other side wanted to talk settlement, and I was like, okay, here's the settlement. You dismiss all your claims with prejudice. That's it. And they did it. So, which they had, they needed our consent to do it, obviously. But so anyway, that's the way this one ended up. And the only other thing that, again, the patent practitioners here might appreciate, and I would love to hear thoughts on this, is one of our arguments for why this patent was invalid it wasn't just that there was a ton of prior art. There was, but it's even worse. The attorney who drafted the patent copied and pasted a total of about like 2 columns of text from a prior art reference, and they didn't disclose that reference to the USPTO. And that was one of the reference they copied and pasted from was one of the best novelty references that I had.
Oh, weird.
So we were arguing that it was also invalid based on inequitable conduct. And I know that, copying and pasting from the prior art is done, on a fairly frequent basis when you're drafting patents. But I just think that you've got to disclose it to the USPTO. And I don't know that there's really any excuse for not doing that.
Yeah, I think two things, and everybody else can weigh in. I mean, I think one, I don't think actually copying and pasting, at least I don't think most of us copy and paste. There may be a world where I think, at least internally, a lot of our practice is when referring to the prior art within the patent document, but then also citing it with the patent office, we may kind of say like conventionally, in this case, we'd say conventionally CBD has been used in A, B, and C. Our client's invention solves this problem by, E, F, and G. Right. And then, so we don't actually cite to the exact document. We don't copy and paste from it, and we don't cite to the exact document in the patent application, but we do then cite the document in an information disclosure statement. So it's providing arguments to the patent office already, kind of more generally, broadly in the application, but then also still saying, hey, here it is in case, you want to take a look at it. So I'd be kind of curious your thoughts, James, too, on that practice of, kind of admitting that there's something out there, but kind of doing it in a more general way, and then preemptively providing some arguments about why maybe your client's information or their invention is different from what's conventionally out there.
Yeah, I don't think that's a problem. I think as long as you are like if they had disclosed that they got all of this text from this prior art document, I don't think there would have been a problem. Or even if they had summarized it and then still submitted the document, that wouldn't have been a problem. But funny thing is, one of the paragraphs that they copied and pasted was exactly a description like you just provided, where it talked about methods of making liquid formulations are well known in the art. It was a little bit longer than that, It talked about, different examples of liquid formulations, and it said methods of making these are well known in the art. They copied that from the prior art. So it was like a double, a double reference. But the other thing is they copied a bunch of text from Wikipedia too. And that was about like almost a column of text, and it was all about like the different properties and uses of the different cannabinoids. And the way I busted them on the copying and pasting from the prior art, because as I was reading through the prior art, I was like, this looks really familiar. And I went back to the patent and I was like, oh, they just copied and pasted it. But the Wikipedia one, they've got, for each statement on Wikipedia, they've got a little bracketed footnote. They forgot to remove the bracketed footnote number from like 2 of the statements. And I was like, that looks kind of funny. I wonder where they got that. And then I, did some digging and found that too. And they didn't disclose any of the Wikipedia stuff, any of the references cited in Wikipedia for any of that information. And that one was kind of deceptive too, because there were statements in there about like, certain cannabinoids are useful for certain medical conditions and things like that. And if you read it just completely cold, it almost sounded like they discovered that. Like they did some testing and showed that, a certain cannabinoid was useful for a certain medical condition. And that wasn't what it was at all. They just copied that from Wikipedia. So again, there's like I don't know. It seemed highly deceptive to me the way they did it.
Yeah. Well, I feel like that kind of gets to, oh, go ahead, Kristen.
So overall, it's very, very poor form to copy from other patents into your patent, except in a background section, maybe, where you're admitting prior art.
Yep.
And maybe if you're talking boilerplate, like really generic computer type of boilerplate, those sorts of things. And even still, we tend to make it our own. Like I would copy my own boilerplate from my own drafting, but it would be unlikely that I would go out, find somebody else's content and put it into my application, unless I was doing, as Ashley had said, where I'm trying to make a point that conventionally this is what happens, and I would still cite that art. So I would be surprised if you would not win on inequitable conduct if they were using the content, reporting that it was kind of something they did, and not citing it. I would think those 3 points alone, you could get them, but
Yeah.
I don't know.
Yeah. Unfortunately, we didn't make it to sort of the final analysis on that, but
Was
I
it
was
more the
pretty confident.
invalidation, James? Was that the kind of what won the day, is a little bit of the invalidation proceedings for this one, or?
Well, I mean, it's kind of a long story, and it's a bit hard to know. One thing that happened in the middle of this litigation is they filed for federal bankruptcy protection, the patent owner. So that immediately stayed the litigation. And then I followed the bankruptcy fairly closely, because we had a claim against them. And I just wanted to see if there was ever a chance that we could ever get that satisfied. And during the litigation, somebody filed a document. I can't remember if it was one of the creditors or the patent owner filed a document suggesting that there was some kind of like New York investment group that was interested in buying this patent. And for whatever reason, I don't know if that deal like never went through, but my allegations that I'm giving you about this copying and pasting and everything, there's an amended complaint with extreme detail about all this stuff and all of our inequitable conduct allegations. So even the most basic due diligence research would turn up, our position, the defendant's position on validity of this patent. And, I guess it's kind of speculation, but I think maybe that investment group read through that and said, I don't know if I want any part of this. So the patent owner ended up getting kicked out of bankruptcy because, we're going to talk about next, cannabis companies can't file for federal bankruptcy protection. So the U.S. trustee filed a motion to dismiss, and the creditors filed a motion to dismiss, and the judge granted it. So the litigation started back up, and they immediately wanted to settle. So so that's kind of how that ended up. We just never got to the final analysis.
Well, I think the other interesting thing you bring up, James, too, is you're talking about their examples about, kind of the working examples that weren't really theirs. And I think that's like an important and a lesson around, one in the space, I think, as kind of David J was mentioning, that in some areas, especially these more unpredictable sciences, ideally you have examples, and ideally you have working examples. But to your point, James, if it's not your own example, making sure it's clear that it's not your own example, but then also, if it's a working example, making sure that it's clear, like labeled as a working example, past tense, that kind of stuff. If it's a prophetic example, maybe labeling it as such, and, or using like future tense, right? To help the patent office distinguish what's actually been reduced to practice versus what could be. And I know that in a lot of our clients, we find it super useful to provide working examples if they're available, and then even supplement those working examples with prophetic examples to kind of expand it, saying, well, if this is true, then, B, C, and D might also be true, and here's how we would discern that. But yeah, I mean, again, getting back to just showing your work, right? And if you're pulling stuff from other places, in this case, the joke is they couldn't even really say it was AI or anything, because, AI wasn't as big of a thing as at that time, right?
Yeah.
So yeah, interesting.
Yeah. So there's, I think, a looming issue out there that has not been decided, which is whether cannabis patents can be enforced. As we've been talking about, high THC is illegal under federal law. I mean, it's been stated again and again and again, even with all these, they seem to be allowing all these states to allow dispensaries and stuff that should be illegal under federal law. Federal courts have said over and over again that it remains illegal even if they're not enforcing it. And it's not just the Controlled Substances Act. There's also a federal law that says it's illegal for a person knowing that the property involved in a financial transaction represents the proceeds of some form of unlawful activity, to conduct or attempt to conduct the financial transaction which in fact involves the proceeds of specified unlawful activity with the intent to promote the carrying on of specified unlawful activity. And that's known as money laundering. That's generally, that's a federal statute, but it's the general term is called money laundering. And under the statute, specified unlawful activity includes violations of the Controlled Substances Act. So if you're involved in financial transactions with somebody who's violating the Controlled Substances Act and you're trying to sort of facilitate that, you're guilty of money laundering. So it's not just violations of the CSA, it's also moving money around. And then the other doctrine that applies here is something that is known as the illegality rule or the illegality doctrine. And it started out back in the earliest recorded example is from 1725, an English case called Everett versus Williams. And it's the better title that it's generally known as is the highwayman's case. And that case involved one highway robber who sued another highway robber and claimed that he had been cheated out of his proceeds from like a series of robberies that the two of them had committed together. And the court in England in that case refused to consider the suit and actually turned the two men over to the sheriff. So, and then it goes from there. There's a bunch of Supreme Court cases and a bunch of other cases in federal court in the United States that follow this doctrine. And the Latin phrase begins, it's ex turpi causa, and the literal, I guess the translation from Latin is from a dishonorable cause an action does not arise. And the most frequent place, like I just hinted at, where this comes up is under federal bankruptcy. And federal bankruptcy courts just will not entertain bankruptcy petitions that are filed by illegal cannabis businesses. And the main reason is that the trustee will be in the position of either administering an illegal business and, you know, making payments, accepting payments involving illegal activity, or even if they liquidate, the trustee is distributing proceeds from an illegal business, and that's a violation of federal law. And the courts have said the U.S. trustee cannot be involved in that. And there's been one bankruptcy case that's involved IP rights, and it's called In Re MedPoint Management. And the bankruptcy court in that case noted that the debtor owned some IP and was licensing that IP for $8,000 a month to companies who were engaged in the federally illegal but state legal Arizona medical marijuana business. And the court said that this was the debtor's only current source of revenue. So because the court said cannabis is illegal under the Controlled Substances Act, the bankruptcy court, quote, observed without deciding that it is quite possible that the debtor's IP and the IP licensing revenues could be seized or forfeited, that the debtor could be or could have been guilty of facilitation of the crime of a crime under the CSA. So due to the unacceptable risk of violating federal law and administering the bankruptcy estate, the court dismissed the case. So that's a pretty strong pronouncement that if you're even in cases involving IP rights in federal court, that you're on very shaky ground. And like I said, the plaintiff in that case that I handled in 2018 filed for federal bankruptcy protection. It was dismissed under the illegality doctrine. And even outside of the bankruptcy context, the illegality doctrine has been cited in several cases. There was one in Colorado called Sensoria versus Koweski, and it was a dispute over sort of like a partnership dispute over ownership of an illegal marijuana business in Colorado. And the plaintiff in that case tried to distinguish the bankruptcy cases that are, you know, there's a bunch of them involving cannabis-related companies. And the court in that is sort of like a breach of contract case, noted that, quote, the same obstacles a trustee faces in managing marijuana assets, the court in this case has in providing a means of redress. And the court also said that it, quote, may not vindicate equity in or award profits from a business that grows, processes, and sells marijuana. So again, you've got a court saying, we just can't touch this. If we're going to be moving money from an illegal business over to another business, we just can't do that. And then on February 25th, a federal judge in Ohio has dismissed a breach of contract case involving the sale of a marijuana business, which the court said was illegal under federal law, using basically the exact same type of reasoning as Sensoria. And that case is called CCH Acquisitions versus J&J&D Holdings, if you want to go look it up. So again, you've got, again, it's never been affirmatively answered in a patent case, but I think there are great arguments out there. So there are IP cases that have been heard in federal courts, and this is generally, these have been cases where there is a legal business that has a federally registered trademark that is being infringed by an illegal cannabis business. And the court will hear that because these trademark owners are pretty much just trying to shut down the illegal business. They're not really going after damages. I mean, maybe they are, but really they just want it to stop because they don't want their legal product being confused with this illegal product. And it's so silly too, because it's stuff like, there's I can't remember what the company, which company owns it, but they own a trademark on like Sour Patch Kids, the candy. And there was a cannabis company out there selling something called Stony Patch Kids. I mean, it's just, have some originality. And I think there was a different one where a company was selling something that was just like Skittles, but it was Skittles, like with a Z as the first letter. So I don't know. These guys don't really have a lot of originality, but the court will hear a case like that. Because it's not really it doesn't involve the court condoning an illegal activity or being involved in it. But patent cases are a little more nuanced. Yeah.
Or actually a quick question. So even I can't remember what Ohio's status is. Can I go back to the Ohio case? So so federal, illegal, but different states have varying levels of legality. If I'm a Michigan business, so it's legal for medical or recreational, in Michigan. If I'm a Michigan business trying to sell my cannabis business to somebody else and they have a breach of contract, would that hold up versus a state where, you know what I mean? Because
no,
it's
not in federal court.
So it only is a district court, but if somebody appeals it to a federal court, then right? If it were like a district court.
Yeah, if you file in state court, and that's actually, it doesn't have really anything to do with IP, but if you're involved in a cannabis-related contract transaction, you need to have a dispute resolution clause that specifies that any dispute needs to be heard in state court. Patent cases can only be heard in federal court. Trademark cases under the Lanham Act can actually be heard in state court. So that would be really interesting. I don't know of any cannabis related cases under the Lanham Act that have been heard in state court, but in theory, I guess it's possible.
Right.
But yeah, no, I mean, if you've got a patent and you want to sue somebody, you got to do it in federal court.
Mm-hmm. Yeah. Okay.
So, but other transactions, you can specify that it has to be heard in state court, and that will survive, according to the legality in the whatever state you're suing in.
Yeah.
So I've seen there was another case where instead of dismissing the case, the court sent it back to the state court. It just sort of like abstained and sent the case back to the state court after it was removed. So that's one option that could happen. I guess if somebody tries to remove you to federal court, you could ask to send it back down because the federal court just can't hear it. But patent cases are interesting because You can get an injunction, conceivably. So if you're asking the court to shut down an illegal cannabis business, that may not be something that a court would see would be violating the Controlled Substances Act. But if you're asking for a royalty, you're sort of asking for a piece of the action. This company's selling illegal products and I want 3% of it, or I want 5% of it. That's kind of sounds like money laundering to me. And I don't know that a federal court's going to get involved in that. I was on the defense side of another patent case where the defendant was in the federally illegal THC business. It was a patent that involved extraction processes. It's like it was called closed loop butane extraction. So you got a tank of butane, you transfer it over to an extraction container. You leave the plant material in that extraction container and get the butane plus extract into a separation container, heat the separator to boil off the butane essentially, and then you recapture the butane and use it just in a closed loop process. And then what you're left with in the separation container is just the extract that you're interested in. So that was the basic technology that was involved. And again, it's like used for lavender oil and oregano oil, whatever you want to extract from a plant, you can do it using this butane closed loop extraction. So in that case, I actually filed a motion to dismiss based on the illegality doctrine. And the court denied it, but not in a way that I think really answers the question. Because if you file a motion to dismiss, the court has to take everything in the complaint as if it's true, and also kind of read it in a way that's most favorable to the company that did not move to dismiss. And what the court found is that the allegations in the complaint and the patent were both broad enough to cover legal CBD and illegal THC. And the fact that it was broad enough to cover a legal product was enough to survive the motion to dismiss. And in that case, we didn't get far enough to answer the question where it was squarely in front, where all the evidence was in front of the court, that the vast, vast majority of the product that they were accusing of infringing was illegal under federal law. We never got to that point in that case, unfortunately. So it's never, to this day, I don't think it's ever really been answered.
That's pretty interesting. It almost gives a roadmap or a path, at least a strategy, because the fact that patents can't be enforced is kind of a big deal. Mm-hmm. It's sort of the whole point of like the grand bargain, where you teach the world about something you're doing in exchange for being able to exclude people for a set period of time, whatever. But like, if you can't exclude people, what's the motivation to file your great process or product? But if you can patent it, claim it in a way that's broad enough to cover CBD processes, for instance, legal processes, then you could focus on
other
that.
oils. Yeah,
or an oil of something else. Sure, right.
Exactly. Yeah. So that you beat me to it. I was going to give some patent
way to go,
prosecution strategy. Yeah. No, I mean, it's good. That's hopefully I explained it clear enough that was obvious. And exactly, you can especially for processing claims. I mean, a lot of them you can just specify plant material and essential oils basically. And I don't think that's, even though that is broader than just specifying the cannabis plant and cannabis, related chemicals, the same principles apply. I mean, you're not going to get around like prior art on lavender oil extraction by saying, oh no, this is cannabis. I mean, it's just not going to work. So
James,
I don't
is there any risk, and if you go to that broad approach where you're covering, lots of different kinds of plants, is there risk in even mentioning cannabis, or in your opinion, is it okay to still, like if you had a laundry list, right? It could be lilac, it could be whatever.
Yeah.
Is there risk in saying cannabis in there, or?
I don't think so. Like I said, I think as long as it's broad enough you're going to survive a motion to dismiss as long as it covers some legal activity. That when the rubber meets the road, though, is if you're going after an illegal high THC product, that's going to come out eventually. And I just really, I mean, I think it's going to be tough. A court may find a way to kind of weasel out of it, but I don't know. It's just I think it's really uncertain. I think you may spend a whole bunch of money going after something that is just never going to happen. So, and of course, they're looking at rescheduling high THC products into Schedule 3, which may change the analysis a little bit. All of a sudden, you're maybe not engaging in money laundering if you're asking for a royalty, things like that. So the legal landscape could change and make it easier to go after high THC products. But right now, I just think it's there's too much risk for me to be involved in that anyway. But sort of like breaking news, it's the last thing I have. In the last couple of days, there have been 3 new cannabis-related patent cases filed. This company called Metronome LLC has sued Biospectrum Hemp up in Wisconsin, and then these 2 companies, Happy Hemp and Floyd's of Leadville, were sued in Colorado. And the patent the claims cover a topical cream application. Again, I think there's a ton of prior art on this thing, just based on my knowledge of, that I've gathered over the last 2 cases, but we'll see what happens. It's interesting though that the defendants in these cases are CBD companies. So my suspicion is that the plaintiff may be a little worried about this illegality doctrine idea and doesn't want to go after high THC defendants because there's some risk there. Because I looked at the claims that are being asserted in these cases, and the claims cover CBD, THC, pretty much anything else in the cannabis plant. So it's not limited to CBD or anything like that, but the defendants are certainly CBD only companies. So that's kind of like the latest salvo in the cannabis patent litigation landscape. So.
No, that was awesome. Appreciate it. So it seems like the takeaways are like, one, it's potentially a risky business to file patents in this space because assertion may be difficult. But if you really do want to, it seems like searching is a must because there's probably a fair amount of prior art out there, especially for compositions and things like that. And I've even heard that for like new strains and plant patents and things like that, like getting biochemical testing of it done, because there's been so many different strains and things like that out there that you want to have the data to be able to prove that you actually have a new strain of something, right? But again, the enforcement of that might be difficult. And then 3, if you are going to file regardless, hopefully you can file it in such a way where it's inclusive of legal things in addition to the illegal aspect that might be part of it.
Yep, that's right. Yeah. And like I said, even if a royalty is tough to get on an illegal THC product, my reading of it is an injunction preventing them from selling any high THC product. That's probably consistent with federal law. So that would carry some settlement value at least. If you've got a court order saying, hey, you can't sell these THC products, it's like, well, that's my business. That's my whole business. So there may be some settlement value there, but what it would entail is kind of like up to the parties, I guess.
But from an injunction relief, how does that is that impacted? You're saying like based on the patent, or are you saying
on the patent? Yeah, you're infringing the patent.
Injunctions are more difficult to get given the more recent eBay interpretations, and so
right. But you again, in the cannabis in the high THC context, one of the factors is whether this injunction is in the public interest. Yeah. And if you've got a federal law saying you can't, clear. You're like, this is exactly in line with the public interest according to federal law. If it's not changed.
That's true. It's less about like, oh, I can't get my Apple Watch at Christmas, and it's more like, oh, this is a Schedule 1 drug.
Right.
Fair enough.
Yep. And then, like, we talked about the other takeaway is claim strategy. Just make sure the claims are probably shouldn't mention THC unless it's like a dependent claim that you're not going to assert. But yeah, just make sure it's kind of broad enough to cover legal activity.
Yeah, that's crazy. Yeah, it's so weird in this like mixed landscape that we're in of having the federal, it's legal at the federal, but technically you can still patent it, and even government agencies are getting patents on it. And then certain states have legalized it in varying degrees, but other ones haven't. And it's like a very weird landscape right now, and hard to navigate in that federal versus state climate.
Yeah. And the trademark stuff too is also interesting. It really requires a lot of thought and how best to protect a brand given the landscape. And I don't know why my career is involved so much cannabis work, but I learned about these trademark issues because I helped this organization called the Americans for Safe Access. It's a cannabis advocacy organization. It's pretty large, and there was a trademark case at the federal circuit involving cannabis tea, and they wanted to file an amicus brief with the federal circuit in that case. So they asked me to help them prepare that and file it. And over the course of drafting that amicus brief, I learned like everything you'd ever want to know about cannabis trademarks and more. So I don't know. It's just been it's been kind of strange, but
yeah. So for the trademark side of it, would you generally recommend filing state trademarks in legalized states as a good route, and obviously leaving the federal side outside of those, however you called it, those
ancillary goods? Yeah.
Yeah.
See if you can get some ancillary goods trademarked, and just go state by state wherever you can get registration.
Yeah. Okay.
Yeah, I really appreciate this, James. This is a hard topic to keep up on in our space, but it's also difficult just following the news to keep up. So this was great.
Cool.
Awesome. Well, cool. Any other questions from anybody or?
No, I found it fascinating.
Oh, good.
Yeah.
It's got a little bit of everything in it. The legality of things from state to state,
Yeah.
yet you're basically you're under the umbrella of the federal government.
Yeah.
That is not legal federally.
Yeah.
Yeah.
Right. So yeah, it's clear as mud, right?
Yeah.
Yeah.
I love the
Yeah.
highwayman case too that you shared from like 1700. That was awesome.
Yeah.
One robber stole for me.
Yeah. Yeah. No, they're the earliest U.S. Supreme Court case that cited the illegality doctrine was like back in the 1820s or 1830s or something like that. So there's a really long history of cases of courts just not wanting to get involved in disputes over illegal activity. I mean, it's just very, very long history of it.
I do have one question. I would assume that there's just going to be more activity in this area because, I live in Massachusetts, so I have that perspective on it, but there's money behind this. There's money to be made.
Mm-hmm.
So I think the minute that happens, everybody starts trying to protect what they're trying to do.
Well, not
in the states, even to the states that have legalized, you see this boon of not necessarily protecting stuff, but like of industries popping up, right? I mean, it's just crazy.
But that's all I have. If there are no further questions, I appreciate you having me on.
Yeah, this was great. We really appreciate it.
Yeah, thanks. Super interesting.
Awesome.
Thank you.
Thank you.
Take care, everybody. Have a good weekend.
Bye-bye.
You too. Bye-bye.
Thanks, James. Bye-bye.
Bye.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.